Welcome to the Deep Dive. We unpack complex subjects, getting straight to the insights from the sources you need. Today, we're tackling let's say a tricky area of criminal law, criminal attempts. And we should mention upfront, we're working from notes made available to students by the University of London.
That's right. And this deep dive is purely for educational purposes, aiming to help you get to grips with these legal ideas.
Absolutely. It's brought to you by Sinorbit Academy, Sri Lanka. And for everyone hitting the books right now, seriously, good luck with those exams.
Yes, best of luck. So, criminal attempts.
Mm-hmm.
It really makes you think, doesn't it, about the why behind punishment. We're looking at situations where someone, starts out to commit a crime, but maybe they fail or they're stopped.
Right. So our mission today is to sort of cut through that complexity. We want to pull out the key concepts, the legal tests courts use, and the really important cases that shaped this law.
We want to help make it stick for your studies.
Exactly. And right away, you hit this kind of core tension in the whole subject.
hmm When someone tries and fails, are we punishing the attempt itself, the wrongful act that almost happened? That feels like retribution, punishing the wrongdoing.
Or is it about the person? Are we saying, look, this person showed they're dangerous, we need to intervene? That's the prevention angle.
Precisely. I mean, think about it. Someone tries to shoot someone, but the gun jams or they just miss their intention, their dangerousness. It might be exactly the same as someone who actually succeeds. So from a prevention view, they're a threat.
But criminal law usually focuses on punishing completed acts,
Right.
on harm that's actually been done. That's the retributive model.
Yeah. So punishing an attempt, especially maybe an early attempt, feels different. It feels like the law stepping in based on potential danger.
And the notes we're using call this conflict a source of destabilizing doctrine. It kind of pulls the law in two different ways.
You really see that struggle when you try to define the or the guilty act for an attempt. Historically, before the big act in 1981, the common law test was about proximity. How close did the defendant actually get?
It had to be immediately connected, yeah, not just like vaguely heading in that direction.
Exactly, not just remotely leading towards the crime.
And the classic case, going way back, is Eagleton, 1855.
That's the one. The baker delivering underweight loaves and then claiming the payment. The court said claiming the money was proximate enough to the fraud because, well, it was the last thing he needed to do to get the money dishonestly.
Ah, okay. But that last act idea caused problems, didn't it?
Oh, definitely. It led some judges to think you literally had to do the very last physical act.
Which sounds impossible for an attempt. How can you attempt something if you have to finish it?
Right. It almost made the law on attempts useless if taken too literally.
Though the courts weren't always that strict. You mentioned White, the poisoning case.
Yes, White from 1910. He'd only given one dose, not enough to kill, so not the last act of poisoning. But the court convicted him of attempted murder anyway, looking at his overall plan and intent.
So there were other ideas too, like crossing the Rubicon from the Stonehouse case.
Yeah, it's Stonehouse in 78. That idea that you've gone so far, you're committed, even as more steps are needed. But these common law tests were just messy and inconsistent.
Which brings us to the Criminal Attempts Act 1981, trying to bring some clarity.
Hopefully. Section 1.1 gives the main definition. You're guilty if, with the intent to commit the crime, you do an act that's more than merely preparatory to committing it.
More than merely preparatory, so still a proximity test in a way?
Sort of, yes, but framed differently. It's about drawing a line between just getting ready, preparing.
And actually starting the job itself, being on the job, as the notes put it, what still needs to be done.
Exactly. And the act splits the decision-making. The judge first asks, could these actions legally count as more than merely preparatory?
And if the judge says yes, it could, then it's up to the jury.
Then the jury decides, based on the actual facts, were the actions more than merely preparatory.
Okay, let's make this real. How have the courts actually drawn that line? Gulliver is a key case, 1990.
Yes, Gulliver. The guy jumps onto the Greyhound track because his dog's losing, hoping to stop the race and get his bet back. The court said, nope, that's merely preparatory. He hadn't actually started the act of theft yet. He was just trying to create the situation where he could ask for his money back.
Right, just setting the scene. What about Campbell, 1991, planned post office robbery?
Ah, yes. Campbell had the disguise, fake gun, threatening note, was outside the post office, but got arrested before going in.
And the ruling.
Merely preparatory again. He hadn't embarked upon the crime proper, hadn't started the robbery itself.
Okay, and that logic helps explain Getz, right, the 1996 case. That one often seems counterintuitive.
It does. Getz. found in a school toilet block with a knife, rope, tape, clearly intending something awful like false imprisonment. But he hadn't approached or tried to detain anyone yet, so the Court of Appeal said, legally speaking, he was still just preparing. His conviction for attempt was quashed.
Just preparing. And, the notes highlight the criticism here. It feels quite detached from reality, doesn't it?
It really does.
Like, how far does someone have to go? Does the would-be robber have to be pointing the gun inside the bank? Does the person in Geddes have to actually grab someone?
That's the practical worry.
Yeah.
The law seems to demand getting very close to completion, which, going back to our first point, maybe doesn't sit well with the prevention idea.
It undermines it somewhat.
Yeah.
But then contrast that with Jones, 1990.
Right, Jones gets in the victim's car, pulls out a loaded sawn-off shotgun, points it at his head, says, "You are not going to like this." Now, he hadn't taken the safety off, hadn't pulled the trigger. Final acts remained.
But his conviction for attempted murder was upheld. Why was that more than merely preparatory?
The court felt that once he was in the car, gun loaded, pointed directly at the victim, with that intent, he'd crossed the line. He wasn't just getting tools ready like Campbell, he was actively engaging with the intended victim. The sequence of acts aimed at the victim had begun.
So even with the 1981 Act, defining the actus reus is still pretty tricky. It depends heavily on the facts of each case.
Very much so. And the Law Commission hasn't pushed for major changes. The notes mention some academic suggestions, maybe focusing on acts directly connected or even listing examples in the statute, but nothing concrete has happened.
Okay, let's shift to the mens rea of the guilty mind. The 1981 Act seems clearer here. Section 1 says it's a crime of specific intent.
Yes, that's crucial. You have to intend to commit the full substantive offense.
And this makes a big difference for attempted murder, specifically.
Huge difference. For actual murder, the mens rea is intent to kill or intent to cause grievous bodily harm, GBH.
But for attempted murder.
Only intent to kill will do. Intent to cause GBH is not enough for the attempt.
And the case for that is Wybrow, 1951.
That's the one, Wybrow.
Yeah.
The electric shock and the bath case. The trial judge got the direction wrong, said intent to kill or cause GBH was enough. The Court of Appeal corrected that, saying, no, for attempted murder, it must be intent to kill. They actually upheld the conviction on the facts, saying no miscarriage of justice, but the legal principle was set.
Got it. Attempted murder needs intent to kill.
And because it's specific intent, recklessness usually isn't enough for the mens rea of an attempt.
Even if recklessness is fine for the completed crime.
Exactly. Take Mohan, 1976, driving fast towards a police officer. For attempted to cause bodily harm, the prosecution had to show he intended harm, not just that he was reckless about the risk of harm.
Okay. And similarly for attempted arson, O'Toole.
O'Toole, 1987. Attempted arson requires intent to damage by fire, even though you can commit the full crime of arson recklessly.
Right. Now, here's where it gets a bit more tangled, isn't it? What about crimes that involve a circumstance as well as a result? Like rape, you need intercourse, the result, and lack of consent, the circumstance.
Yes, this is a really debated area. So for attempted rape, what's the mens rea needed for that circumstance, the lack of consent? Do you have to intend the lack of consent, like know for sure they aren't consenting?
Yeah.
Or is being reckless about consent enough?
And the case law has gone back and forth a bit.
Well, initially there was Kahn in 1990. At that time, recklessness about consent was enough for the completed crime of rape. And Kahn said, yes, recklessness about consent is also enough for attempted rape. If you try to have intercourse, basically not caring if they consent or not, that's sufficient mens rea part for the attempt regarding the circumstance.
Okay, so intent for the act, intercourse, recklessness for the circumstance, consent. And that applied elsewhere, too, like attempted aggravated arson.
But AG's reference, Nova 3 of 1992, you needed intent to cause damage by fire, the result, but only recklessness about endangering life, the aggravating circumstance.
So that seemed like a clear pattern. Intent for results, recklessness for circumstances, but then Pace, 2014.
Ah, Pace. Yes. This case really threw a spanner in the works. Scrap metal dealers, charged with attempting to handle stolen goods. They suspected the metal was stolen. Now, suspicion of recklessness is enough mens rea for the completed crime of handling stolen goods.
For the attempt?
The court in Pace said, quite astonishingly according to the notes, that suspicion or recklessness about the circumstance that the goods were stolen was not enough for the attempt. You needed intent regarding that circumstance, too.
Wow. So Pace seems to directly contradict Kahn.
It certainly seems at odds with it, yes. It creates real uncertainty about the mens rea for circumstances and attempts generally.
Which leaves a big question for students, doesn't it? Especially thinking about exams.
Definitely.
The mens rea for the completed crime of rape itself has changed since Khan. It's now about whether the defendant had a reasonable belief in consent.
Exactly. So what does that mean for attempted rape now? Do we follow the con logic, which might mean recklessness is still enough for the attempt? Or, given the change in the substantive law, is the test now whether the attempter lacked a reasonable belief in consent?
That's a really important point to mull over.
It really is.
Okay, let's tackle the final big area, impossible attempts. You said the common law was a mess here.
Ugh, a complete mess. Under the old common law, you could be guilty if the attempt was just factually impossible.
Like the pickpocket finding an empty pocket.
Exactly.
Right.
Or trying to blow a safe with a totally inadequate explosive. The facts stopped you, but you still attempted it.
But you were not guilty if it was legally impossible.
Right. If what you were trying to do just wasn't a crime in law, even if you thought it was, you couldn't attempt it.
So, the examples the notes give. Shooting someone you think is alive, but they're already dead.
Not attempted murder at common law. Because you can't legally murder a corpse.
Trying to bring in talcum powder thinking it's heroin.
Not attempted drug smuggling. It wasn't drugs.
Buying perfectly legitimate goods because you wrongly believe they're stolen.
Not attempted handling. They weren't stolen goods. In all those cases, you intended a crime, you took steps, but legally, the completed act wasn't possible, so no attempt conviction.
Lord Hailsham summed it up in Houghton and Smith, didn't he? Steps towards something that is no crime can't be an attempt.
Precisely.
Yeah.
It was illogical. So the 1981 Act aimed to fix this specific problem.
Section 1-2.
Section 1-2 says clearly, you can be guilty of attempt even though the facts are such that the commission of the offense is impossible. It directly reverses the old rule.
And Section 1-3 tells us how to figure out the intent in these impossible situations.
Yes, you assess the defendant's intention based on the facts as they believed them to be. That's the key. Not the real facts. What did they think they were doing?
Okay, seems simple enough. Abolish legal impossibility, look at D's belief. But it wasn't quite that smooth, was it? Anderton v. Ryan.
Unbelievably no. Anderton v. Ryan, 1985. 4 years after the act, the House of Lords basically ignored Section 1-3, or misunderstood it. They brought back the legal impossibility idea and quashed a conviction for attempted handling because the goods, which the defendant thought were stolen video recorders, weren't actually stolen. Incredible mistake, as the notes say.
Incredible, yeah. Caused instant confusion. But thankfully, they corrected it quickly.
Very quickly, yes. The very next year, in Shivpuri, 1987, the House of Lords explicitly said Anderton v. Ryan was wrong and overturned it.
Shivpuri was the drugs courier case. Believed he had heroin or cannabis, but it's just snuff or cabbage powder?
Exactly. Harmless vegetable matter. But he believed he was dealing illegal drugs. The House of Lords said, applying Section 1-3, look at the facts as he believed them to be. Based on his belief, he intended to commit a drug offense, and his actions carrying the package were more than merely preparatory.
So he was guilty of attempting the drug offense, even though it was factually impossible with that substance?
Yes. And Lord Bridge, who had actually been part of the wrong decision in Anderton v. Ryan, gave the leading judgment in Shivpuri, clearly explaining how the act worked and admitting the previous error. That really cemented the post-1981 position.
So the act does mean you can attempt the impossible based on your intent and your mistaken belief about the facts.
Correct. Though the notes had a little toda about the voodoo doll example.
Ah, yes. Sticking pins in a doll intending to kill someone.
That's still not attempted murder. The act deals with impossibility based on mistaken facts. It doesn't suddenly make ineffective superstitious means legally capable of causing harm. Voodoo just isn't a legally recognized way to kill someone, whatever the attempter believes about his power.
Right, okay, so it's about factual impossibility based on belief, not sort of magical thinking.
Pretty much, yes.
Wow. Okay, that was quite a journey through a complex topic. We've covered that core tension, retribution versus prevention, and how that plays out in the actus reus, moving from common law proximity, Eagleton, to the 1981 Act's more than merely preparatory test.
Navigating those tricky cases like Gulliver, Campbell, Getz, and Jones.
Then the mens res specific intent being key, especially that intent to kill for attempted murder, Wybrow, and how recklessness generally isn't enough, Mohan O'Toole.
And we flagged that difficult, unresolved issue with mens rea for circumstances, the clash between Kahn and Pace.
Yeah, definitely want to watch. And finally, impossible attempts sorting out the common law mess, Houghton and Smith, with the 1981 Act, despite that wobble with Anderton v. Ryan firmly corrected by Shivpuri.
Absolutely. We really hope breaking it down like this, hitting those key concepts, and especially naming those crucial cases. Eagleton, Geddes, Gulliver, Campbell, Jones, Wybrow, Mohan, Khan, Pace, Houghton Smith, Anderton v. Ryan, Shupuri. We hope that makes it all a bit clear.
Definitely go back over those names and what they stand for.
Please do.
Our aim here with this deep dive was really to equip you with a solid understanding, especially thinking about those exams coming up.
And maybe just one final thought to leave you with, picking up on the nose point about the ongoing uncertainty, like with Pace.
Yeah.
Considering these debates, the conflicting judgments, the fact there hasn't been major legislative reform, do you think the 1981 Act really achieved its goal of bringing true precision to attempts? Or is there still a fair bit of murkiness around the edges?
Something to think about as you continue your studies. Again, from both of us, the very best of luck with your exams.
Yes, all the very best.
That wraps up this deep dive.